assume that that's where they're going to go. I mean, you know that we know at least that one of the main defenses is going to be the prior infirm condition. And you know, for me, as I write demand letters, because I know that's coming in trial, I address it beforehand. And as an example of that, my office had a wrongful death case that we just settled, or are presently in the midst of settling, where this guy had like horrible pre-existing health conditions, and he was on blood thinners. He gets hit in a car crash that was maybe, you know, I don't know, 10, 15 mile per hour crash, but he ends up developing a brain bleed and dies like 3 days later. And so, you know, that's where you take the prior infirm condition law, the jury instruction, and you address that as a lawyer in the demand letter, where we're saying, and maybe you would have as the doctor, hey, this guy probably wouldn't have died but for the pre-existing condition, but that doesn't get the defendant out of the case because the law applies, and basically you use that and you say they're more susceptible, and therefore, you know, they're dead as a result of the accident.
I think you bring up a great question, and it's the when do we do this? What happens is in a state where you have 3 years to file a lawsuit, you, as the lawyer, we make sure that our clients going to great physicians, getting better, making their appointments, and then when we find out the limits, because it's important to do that right away, because you don't, you know, if it's only either none or low limits, you want to move the case quickly, especially if they sustain a serious physical impairment. But during that time, if fortunately this person has protected themselves with high limits or high limits here, when we go to create the demand, that's the stage where we send, and we're going to cover it this afternoon.